find this session really, really interesting. Has to do with the legal issues related to PFAS and the surrounding whole arena of this topic. So I'm going to turn it over to Frank Hearne. Frank is also one of the steering committee members for the forum, and it was really due from a conversation I had with Frank right after they got through this very similar session you're about to hear back in 2019 that I said, hey, Frank, what do you think about? And that's where this kind of whole thing started. So Frank, it is all yours, sir.
Okay, everybody, good afternoon. I was telling Jorge that this is a session that I have to give credit to Jorge for inventing. He always had the lawyer feeding frenzy in Marco Island yearly, and some of the same players here. So thank you for allowing us to use this. I know there's a small fee for the use of the idea. Okay. So anyway, we're here to talk about the legal issues, and that's a really broad topic. We've been thinking about it and writing down some ideas. But you know, part of what the law does is integrate all the various aspects of a problem that the society is facing: scientific, health, economics, politics, business. Every aspect of a problem like this eventually comes and is quickly coming and has already come to the law and the lawyers and the court systems and the legislatures and the agencies. And so we're going to talk about a broad range of things. It's not a sequential presentation with 5 PowerPoints. It's a discussion among friends and colleagues that have worked together for a very long time. I've been doing longer time than most of them, but 50 years or more I've been working on environmental issues. And I think this year and this era of PFAS and the associated compounds, it's one of the most complicated, complex problems we've ever had. And so today I am joined by, incidentally, I am the chairman of the environmental practice group at Mechanik, Nuccio, Hearne, and Wester, and I'm proud to say that it has doubled in size in the last year and a half, which is, we think, is phenomenal growth. We're planning to add another 1/3, another 50% in the next couple of years. So,
and they all have the same last name.
Yeah, curiously, that's right. With me today in person is Howard Nelson, who's a partner at Bilzin Sumberg. Robyn, is Robyn in? Okay, Robyn is joining us virtually. She's a partner at the Akerman firm. Ron Noble, who's the shareholder at Buchanan Ingersoll. The ubiquitous Michael Goldstein, who is the managing shareholder of the Goldstein Environmental Group, and Laurel Lockett from Carlton Fields, who has basically a 3-block walk to get over here from work. So she's in her office virtually. So why don't we begin? I think I'm going to allow you each to have a couple of minutes of an opening statement. Okay, now just try to keep it like 25 words or less. What do you think you want to say about PFAS? And I'll let Howard go first.
Thanks. Always the guinea pig. You know, I think as we learned in the sessions earlier today, PFAS is at one point both the most confusing from a regulatory, investigatory, and remedial sense contaminant that we've seen, but at the same time is also remarkably predictable. And I think the job for all of us, both from the scientific and technical aspects and from the legal aspects, is how we fit the analysis and remediation of PFAS into methods that we're comfortable with, that are replicable, and that you all can give assurances, and we all can give assurances to our clients and our stakeholders and the general public that they are safe from risk.
Well, I hold that thought, because at the end of this, I'm going to ask everybody to predict where we will be on this topic in 10 years. Keep thinking that over. Ron?
Retired.
Yeah, retired.
Waiting for the next PFAS to come. So, you know, I'm just talking to Janet at the break, and it feels a little bit like, 30 years ago when we were in the infancy of some other contaminants, and it's a little bit of the Wild West right now. There's not a lot of rules. There's not a lot of guidance. We got one group going this way, one going the other. So I think as an industry, everyone in the room being a component of the industry, we just need to be mindful of some of the lack of guidance. And I think as an industry, attorneys and professionals included, we kind of rush out to, gather information when we don't necessarily know why we're doing it. So I think we need to, take a step back and let some of these kind of regulatory issues evolve a little bit. And when we do go out and generate this information, you see it on all your projects all the time for PFAS. We don't have any PFAS data. What should we do? We better go stick some holes in the ground and gather some PFAS data. I'm trying to work with folks to be a little bit more mindful. Why are we gathering that information? What do we want to do with that information? What are the implications, liability, regulatory wise? And we're going to have answers, sooner rather than later, Frank.
I hope so. Robyn, would you like to make an opening statement?
Sure. Thank you, everybody, and hello from Orlando. I agree with Ron. I think we need to be mindful and purposeful in how we evaluate these issues and how we generate data, because there are so many questions related to what the analytical results mean on a site and the data that we've generated. How do you manage what you've identified? And since there's only provisional guidance that's come, or provisional screening target levels that's been promulgated, or I wouldn't even say promulgated, right, Michael?
No, they're
that
not.
have been established
They're
by
suggested.
FDEP, so we don't even know what that means. So
Yeah.
I'm in the same boat that Ron is in. We need to be very careful, but be clear with our clients on what the potential risk is related to the compound.
Okay, you can see in our discussion here that a lot of us do transactional work. So we have kind of a take on this problem as being transactional. Laurel, would you give us, include in your statement, a little bit about what you think will happen with the legislative front? I know you recently fought some large battles in the Florida legislature and reported earlier to the group, but
yeah,
could you address that?
yeah, and I sort of following on what my colleagues have said and what we talked about this morning. I think we need to think about how we can get to closure really on these sites, because we don't have really a viable process right now. You have a widespread low-level groundwater contamination issue. Well, with 1,4-dioxane, it might have been a couple of parcels. I mean, this is going to be much bigger than that, and we don't have any real viable tools in the toolbox to come to closure in a cost-effective way, even once we demonstrate plume stability or shrinkage. So, I mean, that is something I think we really, as the regulated community, we need to focus on and think about with DEP. That was actually, as I mentioned this morning, part of our legislative fix. And we never had any objections to it, but we need something there because we don't have a way to get there from here.
Yeah, yes, and what's the focus group that was assembled to handle some of the questions on funding for the petroleum program might be a forum for us to use with integrating the efforts of many of the different professional groups to try to work forward on legislation. Is Steve Hilfiger in the room by any chance? I think he had to go. Michael, we'd love to hear what your opening statement is.
Michael, you're muted.
You're muted, buddy.
Okay, rookie mistake.
Much better.
I'm a bit of an outlier here, likely unsurprisingly. For me, the overarching theme is one of anxiety. And I'm concerned about the potential for interprofessional conflict between environmental lawyers and environmental consultants, and conflict between counsel representing buyers and sellers. Because candidly, I think we're all walking on eggshells here. And there's almost an existential question to test or not to test, depending on which side of the transaction I'm on. And furthermore, whether I'm the lawyer or a principal, I can argue both sides of the coin. I can argue that regardless of whether there are formally promulgated standards or an RAC suggesting a release, that it's better to know, and that we have to know in order to move forward with whatever our agenda is. And if I'm on the other side playing defense, I'm going to argue to the contrary. And I would like to be of the mind that we can proceed methodically and calmly, but I'm reminded of what the esteemed philosopher Mike Tyson said once, which is, everyone has a plan until they're punched in the face. And I feel that this issue is just that. It's a real significant gut punch, if you will, and it's going to leave a lot of us scrambling. So we have the concern about the interprofessional conflict, and then also the concern about exposure to malpractice claims as lawyers and as consultants, depending on whether we recommend testing or we don't recommend testing. And there are all kinds of flavors with respect to how that plays out.
Yeah, and it's unpredictable that standard of whether you're malpracticing or negligent or just simply wrong or mistaken is unfortunately going to be played out in the context of litigation, which isn't necessarily the best way to resolve our problems.
And probably more important for environmental consultants than environmental attorneys, quite honestly, because we're in many cases relying upon reasoned recommendations from our consultants, whether to test, whether not to test, where to test, where not to test, what's a problem, what's not a problem. And they probably have a keener edge to the potential malpractice aspect of it.
Well, actually, when I was in-house at a consulting firm many years ago, I routinely researched where lawsuits came against the conditions under which consultants got sued by their clients. And it was much more likely that a consultant who, let's say, he says, this place has PFAS, putting in the modern context, you shouldn't buy it. And deal A goes away. Guy B comes along and buys it. Okay, that's the more common lawsuit.
Right.
A sues saying you gave me bad advice and drove me away and made my deal collapse. And so just keep that scenario in mind, because one way to analyze this as a professional is always tell them to test, always tell them to look. That's very dangerous.
Yep.
Now again, that's kind of in the transactional a context of this problem. And of course, we don't have any problem telling a buyer, if we're representing a buyer, to test for arsenic. It's got a standard and we know what happens if it's exceeded. The problem is in the twilight zone here. We don't know the goodness of the standard that we're comparing it to. It's certainly not enforceable as a standard. We don't know whether it will turn out to be correct. So we are forced to make our objective standards and our recommendations in the context of uncertainty. And the only way I know of to frame that is to explain everything to the client and tell them this is a business judgment on your behalf. You have to make the call here. And frankly, there can be other materials that we haven't even thought of yet, that they're going to come up in the same context. So that's sort of in the transactional. We all sort of, I think, put a lot of, Laurel suggested something on the legislation, but we were in kind of the transactional theme there. Let's go with that. And let me ask you about what you think will happen in the transactional world. We talked about buyers and sellers. What are you seeing, and have you seen reactions from lenders? Because another player in this, of course, is a lender. Howard?
So what I'm seeing a lot of, and it's similar to another scenario. I've got clients who have a distance requirement from landfills to start testing for methane. Mm-hmm. I don't care what your electronic data search shows. If you're within a quarter mile of a landfill, I want you to test for methane at the boundary. I'm getting a lot of the same response on landfills, on firefighting facilities for PFAS testing.
Mhm,
If you're within X distance, I want to test it the boundary.
mhm, mhm.
And
In the context of lenders, forcing this on a buyer? Or
in the context of buyers and lenders.
yeah. Other thoughts on that? What are you seeing from lenders?
Right now, it seems to be limited to a lot of source property investigation. I think Howard's talking about the migration of contamination from a landfill or another source property.
Mhm,
We're not really seeing the lenders, or the regulatory agencies taking a significant interest in what we call the offsite migration, right? I mean, we've got pretty good guidance at both the state level and federal level that if it's migrated from an offsite source property, you don't have any responsibility for the cleanup or the cost of cleanup. Okay. So a lot of these landfills, we are quite frankly assuming, we know which way the groundwater flows. We're assuming that out of that landfill or out of that firefighting facility is a down gradient property that we likely have PFAS impacts in there. And we have not gone out to do the sampling to confirm that.
So
We've structured the deal to assume it's there.
Ron, you've worked through the regulatory liability. What the lenders and a lot of my buyer clients are looking at is the non-regulatory liability of you should have looked at this, you should have known this, and you're now selling industrial space, residential homes, townhouses, where there may be access to PFAS contaminant. And while you have the ability to go back to the source property, it's not like you're not getting sued as well.
Yeah, and especially with residential property in Florida, you arguably have the right to disclose material defects to the extent that you are aware of
Or
them.
the obligation.
Yeah, the obligation. Yeah.
Which is one of the reasons we did not go create that data.
Frank,
Yes.
this is Michael. I'm not seeing it. I'm not seeing any pushback from lenders yet. Lenders are like those poor lobsters in the pot, and they don't realize they're not going to realize they're done until it's too late. They're slow to react.
I think they're usually, good point. I think they're usually slow on the
They're still
uptake.
recovering from COVID.
Yeah.
What I'm seeing in terms of pressures on transactions, interestingly, is from the insurance side. I mentioned this in the last panel. We are seeing the underwriters very quickly respond to this threat, to this risk, and they are trimming their sails considerably, both in terms of new paper and renewals of existing policies. And as a side note, an interesting implication of that dynamic is that I've started to see developer clients take a greater interest in the liability protection under the Florida Brownfields program as a court of last resort. Whereas previously they weren't interested if there wasn't enough on the tax credit side. Now they're being forced to take a second look at it from the liability protection side.
Yeah, we're seeing that too, Michael. The people come to us who are led by the liability protection and not all that interested in the money side of it, the VIC-TIC and the other. Obviously they'll still get those, but we were kind of shocked when that happened the first time. But it does help you definitely with property damages. Insurance, of course, the pollution legal liability coverage. All they need to do is write an exclusion in a new policy. They could exclude whatever they can negotiate to exclude, and they could exclude this liability if they wanted to, and that's what they're going to do, I'm sure. As you say, it's a little bit different about a existing policy and on renewals, and that also depends on what the market is between the various carriers. But I think
at this point, I mean, most of the carriers just are flat out excluding it from coverage.
Yeah.
I mean, they're just running from anything. It's just a flat out exclusion. I agree with Michael on the lenders being the lobsters in the pond, not knowing they're about to be cooked. But I think all of that will come to an end with the new update to ASTM later this year.
yes,
Which is going to specifically, obviously PFAS, it's not a hazardous substance, so it's not going to be necessarily a wreck, but they are going to be addressing emerging contaminants. And I think sort of flagging essentially for the consulting community, maybe the need to address those as business environmental risks where, sometimes I think that is sort of managed in a phase one. You know, maybe the BERs aren't talked about because we don't want the lender to get upset. And I think the consultant is going to be in a much more difficult position when the new standard comes out and really, you know, forced essentially, and probably forced by their carriers to flag the issue affirmatively. I'd be interested in what our other panel thinks about that.
Yeah, I'm glad you brought that up. The ASTM 152713 has a new, I forgot what they call it, red line that the proposed changes are out within the last 10 days, I would say. So if you do phase ones, you ought to go look at that and see what you think of. And they do a lot of work on the definitional parts. So
yeah, I mean, it's supposed to go to final vote this year. I mean, obviously it's been through its consensus process. It's been in the works for quite a while, but I don't know when the vote is. Does anybody else know?
I don't recall. Anybody else know?
Frank, I was going to make one comment on Laurel, that you were saying that your experiences, and Michael, that the underwriters for site pollution policies are blanket excluding PFAS. I've got a situation that on a transaction I'm involved in right now, not in Florida, but in states in the Southeast, and 13 industrial, well, I guess that's not true, 10 industrial properties. And the underwriter did not exclude PFAS at all. I mean, it's not necessarily an industry that's specifically identified as having PFAS related impacts, but it's an industry that we may see in a couple years will be a PFAS related industry, and we bound the policy, 10-year policy, that did not exclude PFAS. So don't write it off. You know, it depends on your underwriter, and I'm sure it depends on the situation, but you know, I thought that was interesting that it's not excluded.
If the language though covers hazardous substances as that's defined, then it could already be excluded because it's not a hazardous substance. I'm just guessing, but yeah, if underwriters on these environmental insurance policies, they're all manuscripted or pretty much cut from whole cloth, so they can vary quite a bit in the language, even between underwriters with the same company.
Right.
So there was a mention, we've touched on this topic several times, but I think we ought to revisit the issue of PFAS litigation. And I was thinking about this earlier, and I was thinking, is PFAS going to be the litigation model of asbestos or cigarettes or the mass tort type of thing that generates huge amounts of money for lawyers and doesn't really address the issue? We're focused in our environmental work on addressing the issue, but in addressing the injury, is there a documented injury that, like in asbestos or like in cigarettes, which could be attached to PFAS? And are we going to see the mass tort? Obviously, Aaron Breckenridge thinks that there's some money to be made here, or she wouldn't be looking under the tent. So what do you think? What does everybody think? Is there a real personal injury type lawsuit? I think there might be a property damage type lawsuit. Let's put that aside for a minute. Is there a real class action? Yes,
Oh, definitely. I mean, and we have one major personal injury case that's already been filed here in Florida. It was one of the MDL cases, the Batista case, that involved alleged personal injury at the Ocala Fire College. But there are PI suits all over the country alleging, I think there's some birth defect issues historically that were associated with the Parkersburg case we talked about. So yeah, I mean, that's definitely out there. And obviously the Florida Supreme Court case that added personal injury to the suite of damages under 376, 313, you know, that is a major angle potentially for litigation here in Florida.
Yeah, the Simmons trucking case that said that you could get damages for personal injury was thought to be not available under the under the Florida section of 376, but Simmons Trucking said that personal injury was available, which makes it strict liability, as I recall. So was that Michael that wanted to chime in there?
And it was, Frank. And what I was going to ask Laurel is there a Lupo case count in the complaint under 376-313?
You know, I have not looked at that complaint, but I know that a lot of the complaints that have been filed in Florida have a 376-313. So I would assume if it didn't, it probably has already been amended or will be. You know, because it's strict liability and it's attorney's fees.
Yeah,
Right? It's a perfect storm, right?
I was going to mix in that you could get attorney's fees under 313 too. So it's
Frank, one other observation with respect to your very good question about the potential for bringing public health injury claims. We had a toxicologist in one of the earlier sessions speak to some of the adverse health impacts associated with PFAS exposure. That very brief mention, your very good question suggests that a follow-up conference focusing on the public health aspect would be appropriate. Because I'm unaware that FDOH is significantly involved in this area. And if they are, they haven't done much public outreach.
Right. And, you know, I understand because one of the two bellwether cases in the state is the Stewart site. And if you look at the DEP study on the Stewart site, there is a down gradient residential community on wells, and a substantial number of those wells have appreciable PFAS uptick in the potable wells. And there are more than a couple of personal injury firms snooping around trying to put a class together. And I didn't mean snooping disparagingly.
Yeah, I understand.
Scouting.
Investigating, which is what they
investigating.
should,
Yes.
that's what they should do. What else do you think will occur as we go forward on there's going to be other types of litigation involved here. If the feds pass a standard, that will be litigated. Possibly if DEP passes a standard, that will be litigated. Let's switch.
What about DEP applying a non-adopted standard?
Yes, let's switch our focus to the present suggestion of the level that's suitable.
Right.
Talk to us about that. What's the?
So DEP has a non-adopted standard, which they are applying.
Yeah.
And I think the conversations revolve around it are interesting because there's discussion of filing a 120 appeal to set aside a non-adopted standard to make them go to rulemaking. I wonder from a potential plaintiff's attorney point of view how effective a conversation in front of an administrative law judge of, yeah, I know it's carcinogenic and I know it's a public health threat, but they can't enforce the standard because they haven't adopted it yet. So they should just not enforce anything. And I say that in full knowledge that the successful appeal against the contaminant release notification requirements, that argument before the ALJ was not dissimilar to this. They don't have the ability to make us notice it. And, you know, DOA had no problem striking that down. So, you know, maybe I'm wrong. Maybe an ALJ would strike down DEP's attempt to apply a non-standard. I just find it hard to believe in the eyes of public perception that they would do that.
It's going to be a tough sell. And then, you know, the reality is we're going to have a standard, you know, sooner rather than later. So this it's a hypothetical right now that we're dealing with. And we've got a number of sites, especially representing these small community firefighter districts that don't have budgets to go do a full PFAS investigation after DEP has come and done a presence absence test. We're pushing back now and telling DEP we're not going to do any additional work. And right now that hasn't really played itself out. I don't think anybody has called the bluff, but the reality is we're going to have a standard sooner rather than later. And, you know, it's going to be like any other standard ostensibly. And I think Laurel hit the nail on the head with her introductory. We've just got to figure out a way to roll this into our existing 780 process, unfortunately, on a much wider basis. Go ahead, Laurel.
Yeah, and just from a public policy standpoint, and I mentioned, my client, 53,000 population, what is the appropriate way to fund and deal with this? I mean, if it ultimately will be a taxpayer problem for some period of time until there's a broader source of funding, but should it come, on the backs of a small community that happens to have an airport which used AFFF because it was mandated to, or should that be something that the state steps up and deals with? For example, New York State a number of years ago put together like a huge multi-billion-dollar fund to deal with stuff like this, and that's how it's being funded. So I just think we need to sort of from a policy perspective, the state to look at this, and is it really fair and appropriate to take the smallest, local governments and pick them out and make them the targets of enforcement, rather than deal with the problem on a more holistic basis.
Robyn, you have any thoughts on that? You hear me, Robyn?
No, I'm here. I'm trying to unmute myself. Yeah, Frank, I agree with Laurel. It doesn't seem like that's appropriate to put it on the backs of the smaller communities. But I have a situation where an industry had a fire, and then 3 different municipalities responded to the fire, and luckily put out the fire, no loss of life, all is good. But now the industry is working to clean up the release associated with the foam that was sprayed. And so I'm looking at it from the standpoint of how do we clean this up? Whose responsibility is it for the foam that was sprayed on all the neighbors' property? Is it my client's responsibility, since the fire was on their property, and the firefighters all came and sprayed it everywhere? And interestingly enough, Frank, the safety data sheets that we received do not identify any of the, what I'll call the main PFAS constituents, the 29 that are typically sampled for, and none that we have, not the PFOA or PFOS, that there are the provisional standards. So in that situation, what do you do? What is that? Our kind of response to DEP is, we're not going to sample anything else because it's not, anything that is readily available to analyze. So, that's kind of a different spin and a different response to your question. But
well, is anybody here aware of a situation either already at the point or arriving at the point where there would be an administrative action which could be challenged, taken by DEP on the basis of the guidance levels? I'm not aware that they've done anything that would get them to the point where they're going to issue an order, and I seriously suspect they probably won't get there. It reminds me of the kerfluffle on landfills some couple of decades ago, when DEP decided one day that they were going to write letters to the city of Tampa.
43 different landfills.
Yeah, 43 different landfills.
Regulatory landfill letter.
Right. That said, by the way, all these landfills you guys operated for many, many decades, they're actually 62,780 cleanup sites. And we want you to file site assessment. Laurel remembers this one too. They file site assessments and begin cleaning those up. And the city of Tampa basically said, "Go pound sand, please." Never said another
Which
word.
would have cleaned it up, by the way. They pounded it up.
They pounded sand.
And we really have two different
Exactly.
factual scenarios right now,
Yeah.
Frank, where DEP is sending out these 62,780 letters. They've got the one where they've sent their own folks out, or somebody during environmental due diligence has confirmed
it.
the presence of PFAS contamination, and we think it's on your property, and we want you to go investigate it and do a 62,780 SAR. We've got a second version of letters where the department now has information that foams containing PFAS were used, and we have a realistic expectation that you have impacts and go do a 62,780 car.
Mhm.
And we're pushing back on both sites right
And-
now.
and well, you
we
should.
haven't, yeah.
It's interesting because they don't do the second type of letter there for any other contaminant. I mean, if you had a paper mill on the project.
Right.
Without a release, without a release.
Yeah,
you know.
they say you had an operation here which could have X, Y, or Z that's been regulated for decades. Why do they do letters like that? They aren't doing that.
Well,
They
so is
didn't
the
do-
application of the FFF foam a release?
Mhm.
Because it is technically, and it's not an accidental release, it's an intentional
Sure.
application,
So you-
but it's
It's
still
very
a
much like the
release.
pesticide application issue. It's very much like the use of
Right.
the pesticide used in the intended purpose, but I don't think it's excluded in the way by law that the pesticides are. Maybe it should be.
You
Maybe
may be
that's-
onto something. there,
Yeah,
Frank.
that's right. That may be something we want to try to see in the legislation.
But just
The-
jumping into Robyn's point, what would you rather have? Because this stuff is really the only thing that's effective in certain kinds of fires. You want to
Right.
have like massive loss of property and life
Mhm.
solved by using this foam or not? And then if that decision has been made, who is responsible? Just from a policy standpoint, it seems to me like we have it kind of backwards, or no one has thought about it, or we're just sort of shooting the easiest fish in the barrel.
That's a consideration we're kind of not good at handling in our society and in our government. There's a larger issue. Same thing with asbestos, for example. I mean, asbestos was used in ships and the like because it controlled fires, very similar, I guess, in a way. And so it had an immediate risk reduction of a fairly certain event. And then it became more clear, of course, in the case of asbestos, that it was it contributed to later consequences. But AFFF is the same thing. We use it to put out only particular types of fires, like especially airplanes, obviously, and somebody mentioned the tire factory. Do we want them to do they still use the material? I'm not even sure I know.
Well, they have
Yeah,
containing
yeah.
foams now, and a lot of our firefighting clients
Yeah,
have now switched to non.
yeah,
It's like the dry cleaning solvent, right? They're going to their new greener foam.
Mhm.
But the problem is they have massive quantities and stockpiles
yeah.
of their old foams. And I said, well, what are you doing with it? They said, we have no idea. It's sitting in a warehouse in the back of Station 13 right now.
Yeah.
And we have no idea what to do.
Well,
with it.
there's a whole other take on this. What do you do with all those stockpiles? They've got to be destroyed some way. It's like PCBs. We got to get rid of all that stuff somehow.
Frank?
Yeah, go ahead, Michael.
Frank, I'd like to pick up on something something insightful that Laurel said from a policy perspective, and then tie it back to an earlier part of our conversation about where the litigation will likely be coming from or the administrative challenges. Laurel makes the great point that from a public policy perspective, what's the alternative to using FFF, right? Do we want these fires to rage out of control? Is this not a social benefit? That same policy argument could and has been made. It's fallen on deaf ears, which is the point I'm about to make, with respect to the application of herbicides and pesticides and fertilizers
Right.
in an agricultural context.
Mhm.
If you don't use these substances, well, what happens to our food source?
Yeah.
And sadly, again, that argument from a policy perspective has fallen on deaf ears. What agent, and here's the other point I wanted to make, tying it back to where we think the source of litigation is going to come from, or administrative challenge. Which agency has been most aggressive in being immune to that exquisite policy argument that certain public benefits should provide an exception to enforcement, especially as it relates to agricultural chemicals? Well, that's our good friends in Miami-Dade County.
Mhm.
And we know that Miami-Dade County, Durham has been exceedingly active on the PFAS front, and we're glad they have been. They've been doing their own very detailed analytical investigations and hiring third-party consultants to generate data that's very useful. But they also have a code that provides very broad authority to initiate enforcement based on not only numerical criteria, but narrative criteria. It gives them plenary authority to
Mhm.
proceed at their discretion. And it's very hard to reason with that discretion. And To date, most clients that I represent, and I think most clients that the rest of us represent, haven't been willing to confront that exercise of authority head on. But because Durham has been so active in this area, that's where I see litigation, administrative litigation, challenging formal agency action coming from first.
Of course,
County.
talk to us about a local government like a local government entity like Durham has its own charter with its own powers, different from DEP's, and probably because of the police power, has a broader authority to do many things that they don't need to be authorized for. So talk to us a little bit about the success of prevailing in a suit, if you can. Maybe you have a conflict and you can't, but talk to us about prevailing in a lawsuit against Durham on pushing back on the imposition of a standard that you don't feel is justified.
Well, I'd like to defer to my colleagues on that.
Yeah,
I don't want to bogart the conversation here.
I think Miami-Dade County has shown no level of reluctance over the years to push enforcement in situations where DEP or even EPA wouldn't, because they're weighing is it a winnable case or not. I think Miami-Dade County, for as long as I've been dealing with them, which is 30 plus years, have shown no reluctance to move forward on enforcement. The only problem I think they have in this arena is most of the generators are Miami-Dade County.
Yeah, true.
And that has always been a problematic aspect for them. So note that Miami-Dade County has an RFP out that I think got re-upped for plaintiffs' counsel for PFAS litigation. They're advertising it as a contingent fee outside counsel position
Against manufacturers?
against manufacturers.
Yeah, I think that's right. And that's a whole other aspect of the litigation that's going to take place.
But the generators, if you look at it, I don't think Miami-Dade Durham is going to move after Miami-Dade Aviation Division, and they're not going to move after the Miami-Dade, fire division, and they're not going to move after the solid waste division, which are really the larger generators of PFAS in that county. There's not a lot of manufacturing in that county that is manufacturing PFAS or PFAS related materials.
But apparently there are a lot of businesses or industries who have handled PFAS containing material in the past.
Right.
Because it seems like there's a lot of them all the way down to your local McDonald's, so.
And that's coming, right?
That's coming
It's
too.
not here yet. Right now, DEP has shown very little reluctance to go after, as Laurel said, small municipalities, community firefighting, volunteer systems, that trained with PFAS foams years ago, as well as the landfills, county and municipal owned landfills. So they're an easy target though, right? They're not going anywhere, and they've got a pretty good deep pocket depending on what their budgets are. So that's where it's evolving right now, and those folks aren't real good at pushing back when DEP comes.
But they can push back on the legislative front. That's probably what will happen. The League of Cities and others. Let's talk a little bit about there are certain societal environmental problems that we've elected to handle in different ways. I think there are models there. I'm not talking about a model as being good. I'm just saying one way of approaching it. The cattle dip vat. Okay. The federal government told everybody, all the farmers, they had to build cattle dip vats, and they dutifully built them subject to their drawings and everything. And then they discovered there were terrible things, and they set up a statute which provides for a limited degree, pretty good limitation on liability for cleaning those up.
Regulatory liability.
Yeah, regulatory liability. Somebody can still sue you next door, that doesn't do that. But so that's one model. That's a protection from cleanup that might work. It could be used. The other one, of course, is the petroleum and dry cleaning programs, which cleaned up and have cleaned up and are still cleaning up and will forever be cleaning up, as far as I can tell, plumes from those materials, paying for it by a tax on the products related to something related to those. So is there some kind of similar program that could be applicable here, at least to handle certain types of PFAS contamination and even PFAS injuries.
So I think you need to look at which media you're worried about.
Yeah.
So if you're looking at PFAS contamination of groundwater
Mhm.
over a wide area, and Michael, I don't know that I've spent as much time on the Dade County PFAS study as you have, but my reading of it shows fairly ubiquitous background impacts in groundwater, even away from generator sites.
Mhm.
So the issue becomes if the concern is protecting from potable uptake or irrigation uptake to avoid the spread of PFAS, then I think a great method is one of those governmental projects paid for through the tax base on the water systems. And I am sure every local government is then going to, at that point, look back to the manufacturers and try to recoup any loss. But nobody but the local governments or DEP or the legislature can reach out to large areas and say, these areas need to be connected to potable, to a unified water system.
Yeah, and that connects up to something that Jorge has talked about a number of times, which is using the existing regulations to sort of define the aquifers where this is a real problem.
Right.
That it helps everybody know where we're talking about. That's a separate project, but closely related. Is there going to be a constituency for working out some kind of solution like that, limiting liability, defining the aquifers that are impacted, and it maybe even having some
for alternative water supply to those
right,
people who are connected to it.
right, or advanced wastewater treatment, other things that we need to do. I'm not a big tax guy. I don't like to add taxes, but it seems like it's a good use of public power we've got a big societal problem here. And
that can't be borne on the back of
yeah,
smaller communities,
yeah,
smaller economic segments of those communities. There's, I think, an enormous, and Michael, I don't know if you got to it in your presentation, an enormous environmental justice aspect about looking at PFAS and the effect, because the likelihood of communities that have inadequate unified water supply being also communities that are on a lower income scale is remarkable. You got great 5-acre ranchette communities that are on wells, but that's 20 people living in there. You get other communities that are on a less protected water supply nearer a landfill, and that's the communities that are at risk, and you can't put it on their back to go fix their own problem, just like you can't put it on the back of the small firefighting communities to go fix the foam application problem that I hesitate to use the word they caused, but they applied.
Well, there's any number of small trailer parks, mobile home parks that have their own wells throughout South Florida and throughout Florida. Laurel, what's your thought on how to approach this as a overall strategy?
Mute.
Sorry.
Yeah.
In the legislation we had introduced, we tried to fold that component in because, the legislature can't fix it until it understands the problem. And we had called out a very robust study program between DEP and DOH initially, as sort of the first iteration of the Senate bill. And then, with all of the legislative and budgetary concern, basically told, that's a non-starter. And then we changed it to an analysis by OPAGA, the Office of Policy and Governmental Analysis or something, which would not have had a revenue impact. But we've got to have a revenue source. There's no there's no tax. There's no good analogy to either dry cleaning or petroleum for this. It has got to be an external infusion of cash. I mean, it
Laurel,
has to
even
be a
with-
parents patriae suit, I think.
Yeah.
It just has
I mean,
to.
even if they had a tax on the material, I think our states and our legislature's experience with both petroleum trust fund and the dry cleaning trust fund has been one of such misery, especially for the legislature. I just can't imagine they're going to create another
Right.
program that's tax, funded.
Well,
Yeah,
and you can't,
yeah.
because what are we going to tax? Pizza boxes? I mean,
But
we don't
there's a mirror-
manufacture it here. So.
Okay.
There's a mirror image of the tax program that I think can be brought to bear here. And of course, I'm a brownfields guy, so I'm going to go back to the brownfields world. The mirror image of a tax program is an incentive program. And if we think about priming the pump in a way that gets private capital off the sidelines, that could work. And so maybe in the next session, we propose a standalone cleanup tax credit for PFAS alone. That's a possibility. Right, we've seen the leveraging effect of brownfield incentives. At the federal level, it's 1 in 30. I don't know what it is at the state level, but it's enough of us have been involved in this arena for long enough to know that it's substantial. So if you have a $10 or $20 million annual tax credit bucket for PFAS, and the multiplier is, a 1/3 of what it is at the federal level, it's more than that likely. You're now taking $20 million in tax credits, and you have $200 million in cleanup. Something to think about.
Well, that doesn't have to just apply to cleaning up groundwater. It could apply to water treatment for water supply and for wastewater surface discharges. The municipalities and other people who do those types of things, that could be applied there the same way. That'd be another thought. Robyn, you want to join in what do you think here?
Yeah, what I was going to say is, I agree with those thoughts, but I'm back to Laurel's first question. How do we get the closure on these sites? And perhaps it's obviously more difficult on the sites where they're on private wells and there's not a public water supply. But if there is a public water supply and the water supply is not impacted, so what is the end game? What are we trying to clean up on these various sites? So Michael, in the cleanup tax credits that you mentioned, I kept thinking, well, what is the cleanup? What is the fix? What are we going to do on all these sites? And what is our cleanup target level not on a specific number, but on a broader perspective? So that's what I'm still kind of struggling to figure out. At the end of the day, what are we trying to accomplish? We can identify the funding sources and work through the legislature and do various things, but what are we trying to accomplish? What are we, where are we going?
Well, I think that's the same question we have for a lot of our programs. What are we trying to do here? Where are we going? And are we going where we want to go? I mean, I think that that's a great question for practically everything we do.
Well, I want to rise to the challenge. I want to rise to the challenge that Robyn put on the table. From a brownfields context, I think what we're doing is we're most directly trying to find a viable funding source. If it's not available at the public level through a new tax, it may be available at the private sector level by using an incentive to encourage the voluntary commitment of significant levels of private capital. That's number one. And in doing that, right, in getting that money off the sidelines, that private capital money off the sidelines, and influencing its investment in PFAS impacted sites, we're expanding the scope of PFAS cleanup across the state. We're accelerating it. We're expanding public health protection, right? And we can, just like the legislature did with certain organoleptic standards for brownfield cleanups, we can create a separate suite of standards that achieve closure for brownfield sites. The public policy perspective is preservation of open space, acceleration of cleanup, expansion of public health protection, acceleration of economic empowerment on an equitable basis. And we could even draw those lines tighter if we want to, as Howard pointed out, focus activity on environmental justice communities, which are the most vulnerable, then as a subset for these tax credits, we make them only available for redevelopment in environmental justice communities as defined by certain metrics.
No, well, I think that's a good
That's
idea.
very good.
I think the brownfields program is something we need to touch on in several ways. This topic has the potential to slow down brownfields development because of the uncertainty of what's going to happen and the ubiquitous nature of the threat. For example, on landfills, I mean, we've done any number of landfills, God help us, you know, they've been redeveloped. And will it affect the redevelopment of landfills that PFAS is increasingly an issue, or other sites? So what you're doing would also not only help address the problem, I think it could be done to add to water treatment and the like too. But just in the redevelopment side, it would help stop that decline in brownfield sites. So I think that's something we ought to. I'm seeing Steve Hilfiger here. He's raising his hand. That's where we ought to. Steve, you want to talk about that? We've had some discussions about moving forward on the brownfields legislation coming up. You want to go ahead?
Well, yeah, I just wanted to. Well, thank you for the opportunity, Frank, to contribute to the discussion. I see this in two ways. One, we have a site-by-site type of scenario where there are plenty of solutions that are on the table that we can talk about through brownfield associations and other groups to look at a site for closure strategies. And I think we can get and gain a lot of momentum and have solutions there on a site-by-site basis. The larger problem is the community and the statewide problem with 900 to 1,000 people moving here every day. More and more of the clean properties are being bought and developed. What developers are left with are sites that are impacted, the inventory. So how on a larger basis with the environmental justice issues, with the, take a former 1,000-acre agricultural parcel that was in the 70s, but now has, through legal label application, has now impacted a number of sites and now impacts the community. But there's really no longer a source or a liability source. How do we address some of those larger issues? So I think that a lot of ground can be gained before we have an early session coming up next year. It starts in January. I don't think there's any time to waste. We need to continue to pick up on the momentum that we've developed through many associations getting together this legislative session to organize and educate the legislature. We should pick up on that work and continue these discussions. And I think there's a lot of opportunities for Florida Brownfields and other associations to gain some ground.
Yeah, Steve and others have pulled together a coalition of many of the professional organizations in the state, which work very hard and very effectively on getting funding returned to the petroleum program. And that same approach, we ought to think about trying to plug some of these types of ideas in as we go forward. I'm much more of a person who wants to see what can we do about this problem. I think it's a pretty scary problem. It's easy to be scared, but we have to do something about it because we need clean water with all these millions of people moving into the state. We've got to solve this or do the best we can at it. And I think we got to work on the legislative front. I think we need to work on a local government front in some ways. I think that's a great thing that might come out of this conference is if we commit to trying to do something about that. Other thoughts from the panelists?
Just one thing on the brownfield side. First, Pensacola, actually year before last, we did late in the session introduce a very surgical amendment to the Brownfield Act that would have facilitated entry of PFAS sites into the program. But I think to some extent, some of those issues are no longer meaningful. The department can't say you're subject to 62,780 and then say, but you can't get tax credits if you're in the brownfield program and have this contaminant you're addressing. So yeah. I think that can't be, that falls by the wayside. But the 1997 sort of threshold date that's in the statute. The party can't have caused or contributed to the contamination after 97. That's going to be an issue for the local governments, the airports, who have been using the firefighting foam, and they're mandated to do it. So that
excellent
would be
point.
something we would have to address. And that date had no magic. That was just the date that the legislation went into effect. So
I think that's an excellent point.
That.
That's an excellent point that needs to be fixed, especially in this context. Others?
So as you go back, Frank, to your earlier point of how is this different from a cattle dip vat, and you look at the application of AFFF, I think it is different because what you've got with cattle dip vats is you've got a groundwater plume. There's no remedial obligation, but that doesn't mean that DEP is going to allow potable wells down gradient of it. So you're still protective. I can't imagine a legislative liability protection fix for the application, even if it was a mandatory application of what is a toxic substance that's surficial on a piece of property that someone else owns, that someone else wants to use, without also coming up with somebody or something that's going to remediate it. And the question is, who remediates it? It shouldn't be the firefighters. I think we all agree. I don't know that it should be the property owner who had the bad misfortune of having his or her property catch fire. So unless 3M writes a holiday check, who's on the hook for that remediation over and above the liability protection that we want to afford that property owner or the firefighters or the local government?
Yeah, Howard, I think the remediation issue is going to, quickly advance to an analysis of risk. We've had our old contaminants, our dry cleaners, our petroleum. They really had to evolve until we all got comfortable, both from a regulatory and a liability and a property transfer standpoint, with the concept of risk and site rehabilitation. I think we're going to realize very, very quickly and advance that discussion that we are not going to be restoring these aquifers to whatever the drinking water standard is going to be, right? That's not going to be feasible, especially if that restoration is going to come on the back of communities, counties, and cities that own airports, landfills, and firefighting facilities. It's not going to happen. So, we're back to, again, what Laurel said in the very beginning. How are we going to address risk, and how are we going to get site closures and address the liability issue along the way so properties can continue to buy and sell?
Well,
and the soil medium. How are you going to address those individual sites?
Soil source areas, there could still be some remedial requirements, but
groundwater
issue.
The other side of looking at that, go ahead, Robyn, go ahead.
No. I was just going to add on to Ron's point is, DEP's approach to these sites before you can get to a risk evaluation, they want the sites fully delineated. So how are we going to even get to the question of risk if we can never really fully delineate it, if there's, these fairly low level ubiquitous levels of PFAS in the groundwater everywhere anyway. So, it feels like a very circular discussion. But I agree that's what I think we have to identify is what truly is the risk and what are we trying to achieve and protect. Because I'll tell you that DEP is saying right now, on sites that have fires, you need to do a 62780 assessment for PFAS, period, in all media.
So that's Michael.
You're on mute, Michael.
Have they issued that in writing, that directive?
Yes, they have.
Could you share that? I'd love to see it. I haven't seen it.
Well, so I think somebody asked earlier if there was an actual written action that could be appealable under 120. And I think Robyn just pulled the rabbit out of her hat.
Yeah, if that's an order of the department, then it's certainly appealable. So.
It is in the form, Michael and everybody, of a comment letter to a site assessment work plan related to a fire that occurred at my client's site.
These are.
So-
Was that from a district office or Tallahassee?
The comment letter came from a district office, from Central District,
Okay.
District, but this is a very very complicated and heavily focused site, both by the district and Tallahassee. So I'm certain that the letter before it went out came from review both of district and business support and the RCRA section, because there's
Oh,
a
yeah.
RCRA
The RIC was
component.
You know,
No.
speaking of RCRA, I fear that we are going to go much deeper in the hole before we come out on the other side. Someone used the term chaotic to describe the regulatory framework. I see another level of chaos when impacted third-party property owners, dissatisfied with a hands-on approach that DEP and local government environmental control programs, pollution control programs may take with respect to sister agencies. I see those third parties invoking citizen suit provisions at the federal level under RCRA and at the state level under 403.412 to seek injunctions to compel DEP to pursue enforcement against the local government responsible parties.
That's a very likely scenario. That's a very likely.
Or in another particular situation that I may be involved in, they may be considering RCRA citizen suits against the company that had the fire.
I'm sorry, against who, Robyn?
The company that
Against
had the fire.
the company that had the fire.
Yeah,
Right, because of that strategic fire they had.
yeah.
Yeah, yeah, exactly.
You silly guy.
Because they wanted a fire at their facility. No, but Michael, we have received a 90-day notice of a potential RCRA citizen suit. A RCRA citizen suit has not been filed. The 90 days has expired.
And when you say we, is your client a government entity?
No, it is not. It's a private entity.
Okay.
When I say we, my client has
Yes, no, I know.
received notice. Yeah.
Right, but the point I'm trying to make is that
Non-governmental, private entity.
the
And
point I'm
without
trying to make-
identifying Robyn's client, they had the fire.
Exactly.
Exactly.
Just one last
Michael.
point, and then I'll defer to the group. The point I wanted to make is this, that I think it's going to take the exquisite level of pain that can only be articulated by multiple local governments across the state to force any kind of clarity from the legislature.
That's a good point, Michael.
I mean, that's really where we were, and we had the League of Cities, was heavily involved, co-authored essentially the draft legislation. And it's just, it's a multi-year process essentially with something particularly as complicated as this, to bring people up to speed, to understand what the issue is and what it's going to take to address it. The only thing else I would add is that we really do, though, have a model, though, because we had this whole situation with EDB.
Yep, that's where that delineation rule came from. Yeah.
Back in the late 90s or early 2000s, 500,000 acres across the state. I don't remember how many counties, but an enormous area of the state is subject to delineated areas where wells cannot be installed for potable purposes. And guess what they're directed to do at that point? It's mandatory connection to the municipal water supply. And for that rule has not been used for anything else really subsequently.
And did it really solve the problem? I mean,
it did in part, right?
Yeah.
Because, but it was sort of at that point without technology, it was kind of like papers, maps, and now we have the technology of GIS layers and all of that. But
except the PFAS map might be the whole state,
Well,
And you may see a day where the whole state is connected up to a unified potable water system.
Well,
Yeah.
and I think this is a wonderful discussion. I want to try something, see if it works out. I want to do a lightning round here. And I'm going to ask you
Uh-oh.
questions and you have to say yes or no or a percentage. And it's all about where we'll be in 5 years, other than me retired. I will be retired. But in 5 years, where will we be? Okay. We will have an enforceable standard for PFAS family from FDEP.
Yes.
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 Robyn?
I'm sorry.
Will
I
we,
can't envision that far in the future.
we were doing it. we
Sorry,
were
no,
doing
no,
a
as
lightning
you're
round.
speaking, one of the DEP people was emailing me on something. I was like, what?
Yeah,
And
probably
I'm-
sending you that final order on that fire. site.
no.
Yeah, yeah. I know how those people
Yeah,
are.
I'm just trying to figure
Well,
out
the
what.
question
what
was,
it's
will we
like.
have an enforceable DEP standard for the PFAS family, I'll call it,
In 10 years.
in 5 years?
5 years.
5 years.
Will we have an enforceable standard in 5 years?
Yeah. No, okay, 4-1, yes. I say, I think we will have a standard in 5 years.
Now, bear in mind, we haven't updated
Yeah.
the CTLs in over 5 years. So we've been trying to
Right.
do that. So,
I
so
think
Robyn may be the correct one in the group.
Right. No,
think-
exactly. I'm saying I'm not saying we will have a standard, but whether it truly is enforceable and defensible, that's where I'm coming from.
That's the
my-
lawyer's answer because it'll still be being challenged through the administrative process.
I think the
Okay,
bigger
second-
question is how many times will that standard change over the next 10 years?
We'll have that later.
Okay.
The
Hey,
second
Frank?
thing is,
Frank, before you get to the second question, real quick, if you speak to Brian Doherty in Tallahassee, he will tell you that the provisional standard is enforceable now.
Mhm.
But
Yes.
having said that, will we have a formally promulgated standard in 5 years? I vote yes.
Yeah.
I'm, by the way, Michael, I'm 6'2",
Okay.
and that's about the same level of accuracy. for those two statements.
Will there be, in 5 years, will there be widespread or numerous, or let's just say frequent DEP efforts to cause cleanup under 62-780 for sites that are primarily PFAS sites? 5 years, yes, no?
Yes. I think so.
Yes. Yes,
No.
but-
Say
but
yes.
using 62-780 with some of the risk-based tools, right?
Yeah,
that we
yeah,
talked about, not-
yeah,
not-
including the risk-based tools.
And-
That's
I
that's
think
where
it-
they're headed.
Right.
Yeah.
I think it's no. I think they're going to continue to pick the easy fruit, but there won't be widespread enforcement.
Okay, Robyn,
I said I agree with what Howard just said.
say that again?
I agree with Howard.
Okay.
There's a first.
Okay.
Howard and I usually agree. That's not true.
Okay, the next one is, well, in 5 years, where there'll be some kind of public funding for the municipalities at least to address the issue for the cities and counties.
No.
5 years?
5 years.
Yes, I think we'll have.
I say hopefully yes.
Yeah.
Yeah.
Hopefully, yes.
We'll have
10 years.
something, and if not, we'll have some sort of kludge on the Brownfield Act to provide some coverage, partial coverage.
I like Laurel's response. I vote no. I don't think we're going to have it, but I'm hopeful and optimistic that we can create a separate incentive through the Brownfields program. Public
Okay.
policy supports it.
Okay, and the last question is, will you be at Marco Island for Jorge's lawyer feeding frenzy next July? It's this July. I'll be there.
In
I'll be
person.
there.
I'll be there.
Okay, good.
I'm
There'll be no
on
beach party,
Michael's
unfortunately.
panel. I'm not on Jorge's panel.
Okay.
Go,
We'll have to
Michael.
work- We'll have to work on that. The ubiquitous Michael Goldstein.
How did
Yeah,
that happen?
How did we let her get stolen?
I don't know.
Okay, well, I got 15 minutes left. Let's open it up for questions. Were there any hands raised in the on the virtual group? Anybody back there? Clue me in. I can't see it up here.
We've got a couple live.
Okay, we got some live folks. Let's let Jay go first here.
So Frank,
Jorge.
Frank, if you had a client that was going to buy Robyn's site, what would you advise them? Would you have them do a full PFAS type of study? Would you advise them not to buy the property? You know, what would be your advice, or the panel as a whole related to that site?
Well, first of all, it's,
And-
And,
this is-
and let me interrupt and add real quick. Remember, on my site, the safety data sheets we have shows that there's not any of the 29 PFAS constituents that were in the foam. So it may not even be a PFAS issue at all. But I think that's an interesting question. Can I add to your question? Would you advise your client, Michael Goldstein, to sample the site before you buy it?
That is the
Wait,
question.
when did
exactly.
Michael Goldstein become my client?
I think
Happy
there's
to
a
have you,
conflict.
Michael, but
I think
I
there's
need
a
a retainer.
conflict there. I think there's a conflict.
I'd be honored to be represented by anyone on this panel.
What the question is, which I think is an interesting one, is what do you advise a buyer of Robyn's site, which as I understand is a RCRA site that had a fire within the time frame where PFAS could have been used in the attack or in the firefighting. Is that correct, Robyn?
No, I amended it to say, as far as we know right now, the safety data sheet says the AFFF does not contain any of the PFAS.
Oh, right.
constituents
Okay.
of
Understood.
concern.
Understood.
Yeah.
And Robyn, there was nothing in the processes at your clients or stock in your clients'
No,
warehouse that was a PFAS or PFOA generator?
no, nothing.
Okay. I know Travis will know why I'm saying this is that let's focus on buying this RCRA site to begin with. There's some risks here.
They're not
There's
selling.
risks.
They're not
recreation
selling.
on this site. The only potential issue that's already been investigated fully. There is no other issue. This is the only issue. Is that there was a fire that occurred that was put out,
Right.
and there's a question as to whether or not PFAS is present.
Right. And I
That's the
think
question mark. And so, that's my question to the panel is, as attorneys, how would you advise your client related to this? Because it's a real life situation.
But again, is there a question whether or not the foam was used?
There is a question as to whether or not the foam was used, but let's say that it was. But even if it wasn't, I mean, I still think you'd want to investigate whether or not it was. And if it was, would you have your client investigate it? And again, it goes back to the liability, Rob, and that's the question that I had is who is liable? Is it the person that put out the fire? Is it that agency that put out the fire, or is it the property owner? So I'm trying to understand all of that because these are real life situations. You have properties that are going through transactions that have had fires. And so I'm trying to understand as a consultant, how am I going to address that?
Well, the first of all, I think the consultant needs to advise on the technical aspects of it, whether PFAS, all of that. But it is a lawyer's job, I think, to sit down with the client and say, here's the situation. There is a possibility that this type of material was used on this site. And you have to make a business judgment about whether you want to test for that now. Because if you don't test and it turns out that DEP moves ahead, as the esteemed panel said, and passes a standard in 5 years that's enforceable, you could be needing to clean this site up. Right now, they can't make you clean. I've had this discussion a number of times. They can't make you clean this up. They don't have an enforceable standard, but it doesn't mean that in the future, they may not come to you. Further, if you are buying the site, you have to think about your transactional partners. You have to think about the lender, the future buyer. If you're a developer who wants to sell it, even future tenants, and how they will interpret this. So do you need to know that information before you buy this property? And
Frank, I want to add in, notwithstanding Frank's conviction that DEP cannot make you clean up the site because they don't have an enforceable standard.
they may still try.
Understand DEP believes differently, and only a portion of it is, at least if you're transactional environmental counsel here, only a portion of it is really what liability do you have for cleanup, because a portion of it is how bad will this mess up your developability schedule?
No doubt.
That's
It's a pitched battle with DEP for 2 or 3 years as to whether they can enforce the standard, keeps you from developing this site. That's something you need to advise your
yeah, it's
client.
all in the context of the transaction,
Right.
especially for the developer who really just cares about the transaction.
And Howard, the directly related to the point you're making about impacts on development schedule is development cost and engineering and permitting and incremental cost for managing impacted media.
Mhm.
That could be a huge number that dwarfs the number related to pushing back against DEP and or putting in some kind of site rehabilitation strategy.
Right.
Let's not forget about that.
Yeah, and also the future buyer or tenant, the universe of the future buyer or tenant possibilities goes smaller every time there's an environmental issue. So you have a smaller universe, which affects your price. And then certain transactions, the buyer or the tenant or others will use that fact to decrease the price. So it has many implications that need to go explained to the client. And I think, especially in many contexts of a sale, you may have a lender there who's out of state or represented by a law firm who knows a lot about this and expect and insist that the work be done, that the investigation be done. But people will make different decisions. I think you have to be very careful how you advise in writing so that you protect yourself, that there are many business judgments for them to make. We don't have perfect answers and perfect accuracy on going forward in these transactions. So, but great question, and one that
I'm not sure we answered as a group this question, though.
yeah, well,
you
other
did.
answers. Robyn, you want to answer? Well, you can. It's your site, so you can't tell.
But it's not your site. We're not talking about your site. We're talking about a site similar to yours.
On my site, there was no AFFF. Our
Yeah.
safety
Right, which
data
is why
sheet
this
says
is not
it's
your
not.
That's right.
So
She
that would
says
be my
it's-
answer to the question. If
Yeah.
you can get the safety data sheet, then attempt to get that may or may not be available. But I tend to fall into Ron Noble's camp where, do we do some sort of evaluation on a transactional level that we assume that it may be out there and try to deal with it based upon that assumption without actually testing?
Well, and the other thing is it should be handled in the transactional document. The seller,
Absolutely.
the seller should when I'm a seller, I say, you can do a phase one, come back to me with your phase one. You can't do a phase two. That's where we start out. And then we work from there. If they say, no, we got to do phase two, but maybe we get to the point where the RECs can be investigated on a phase two. And then we're going to fall out about what the RECs are. And we're going to go to your firm and say, you shouldn't have written an REC here that said that the PFAS is an REC, because we know it's not defending Robyn's position. We know that wasn't used or whatever. So, but the transaction will guide what's going to happen on that site. The seller ought to keep control of, in my view, as the seller, what the scope of such an investigation is, because, and of course, if I'm representing the seller, I explain to them, look, they go out and find it and they go away, you're holding the bag. So
well, let me give you a slightly different take on that. If you let the seller let go of riding the reins on this and let the buyer do the due diligence they want to, but put a confidentiality provision, including a confidentiality provision that does not allow the buyer to release data back to the seller, then the buyer can do their due diligence. The buyer does not have a disclosure obligation. They're not the property owner. They're not the operator. And if they want to walk away from the deal, they can walk away from the deal.
So he comes to you and says, I want to test, I want to do this test. And you say, okay. And he says, I want to walk away from the deal. You're not aware that there might be a problem, that maybe they found bad news. I think that I understand the point, and we've used that too. There is some risk in that one too, that you're and also, of course, it expands to the larger community. Fred or George or Herman or Juanita walked away from that site. Why did they do that? So it's there's room to be burned on both sides. Ron, did you ever answer that one? Or?
I think to answer your question, which we didn't do a good job of, you get with the client on their risk tolerance. Right? And you go through the factors that Frank just identified and you evaluate what their risk tolerance is. If you're representing the school board and they're looking for a new elementary school site, you're probably going to go test. I have plenty of folks and clients that are more land speculators, and they would have no qualms about proceeding with the purchase in a single asset entity and, kind of rolling their dice.
Yep. There's other things you can do to protect yourself.
Can I throw one other?
Yeah, Laurel, I don't think you had a shot at that one.
Well, I want to throw a different role in the food fight here, and just to get people thinking about liability from historical transactions, where there's an indemnity for conditions arising before closing that maybe the seller carries, or or,
Mhm.
the buyer has maybe based on a price concession, agreed to assume all liabilities going forward and indemnify the seller for that.
Absolutely. That's a real
There's-
good point.
Reuse or reopener provisions in enclosure orders. I mean, it's kind of like 1,4-D was with chlorinated solvents, right? Oops.
Yeah.
We forgot to look for this, and then all of a sudden you're off and running for another 10 years.
That's a good
I
point.
think we're looking at a whole suite of litigation and transactional issues that are going to flow from this over the next couple of years.
Just a plug for the panel. So what I would do is I would always recommend that they speak with an attorney. So that they would get a referral for one of you, that's for sure. So thank you very much
Thank you.
for the answer.
There's a gentleman over there that, are you waiting for a question? Okay, you always stand out. I know
Oh,
you.
man.
He's
cold.
always
Leave him
standing
alone.
out. Any other questions in the back? Please come to a microphone.
Lenders use the phase one standard to evaluate a property for collateral, not for innocent purchaser defense, not for any of the other things.
Mhm.
Okay? Piece of property burned to the ground in the 70s, don't have any idea, was rebuilt, they reused the slab. Okay?
Yeah,
Do I have an obligation to disclose to the lender, not to, I mean, my client is the lender, not the guy who's borrowing the money.
yeah.
Okay, the report goes to the lender, it's certified to the lender. Do I have an obligation to disclose the PFAS possibility?
Well, it affects the value of the property since they're looking at it as
Correct.
collateral,
Affects
then,
the viability of the collateral.
yeah, I think you would. Or
Wait a
he's,
minute, wait-
I don't
wait a
think, I
minute.
don't know that that imposes an obligation on you, but that's what.
No.
the lender
Yeah,
will
I don't
want
know.
from you.
Yeah.
It depends on what your loan documents, reps and warranties are, right? I mean,
I don't
And
have any, I don't have any idea. I'm doing the environmental underwriting. Is the property suitable for use as collateral? Yes, no.
But Robert, you don't know, and those, you don't know whether what foams were used, whether foam was used at all. I mean,
Right.
All I
which
know is there was a
why I
fire.
think he's asking you whether he raises it as a question.
I think you should to a lender if you're representing a lender, because it goes to the value of the property, which is what they said, unless your contract says something different.
Right. The
I don't
lender
know-
can make the business risk decision.
Yeah, exactly.
whether or
They have to
not
make the
They
same
think it
decision.
affects the capital enough to want to
Yeah.
inquire.
Okay. Is it inside or outside of the scope of E15-2713?
Probably outside because you don't have any knowledge of a real release.
Okay, thank you.
and it's not a hazardous substance.
Yeah, and it's not a hazardous.
Just to
substance.
plug-
Is this the quintessential BER?
I think maybe so. Maybe that's the
Yeah,
best way.
it's a BER
Wouldn't you think
now.
so? Robert, it could be it's a business risk that you ought to disclose, probably. That's another way to look at it.
I think
It's
Nick Albergo is going to talk about this at length tomorrow, just a plug for his session. I think it's on the ASTM PFAS Nexus, so.
Okay, well, I think we're out of time and I really enjoyed the discussion and we'll see you in Marco Island. So no, we'll see you out having a drink. That's what I'm doing.
There we go.
Oh,
Thank you
good.
guys
Good.
for,
Thanks a
staying
lot.
so late with us.
Yeah.
Drink the water they used for the ice.
Yes. Thank you, Frank. Oh,
Bye-bye.
Michael.